I think it's a very interesting case in many respects. One thing that particularly interests me as a constitutional law attorney is the argument being made on Michelle's behalf that she was entitled to and deprived of the opportunity to have her trial subject to a television camera. She's raising that issue under the Sixth Amendment, which is the constitutional right for defendants to have a fair trial. And I think there's a strong argument that she made, and her lawyer, Stephen Grigsby, made an excellent argument. I thought his advocacy was outstanding on the importance of having media coverage of a defendant's trial if the defendant wants it. Most of the cases that have been addressing that issue have arisen under the First Amendment when it's the media or the public who is seeking access to a public trial or other judicial proceeding. And generally, the courts have ruled that the public and the media, as a surrogate for the public, has a constitutional right under the First Amendment to have media access to judicial proceedings. The argument being made in this case on behalf of Ms. MacDonald is that that position, that doctrine, should equally be applied to criminal defendants. And I think it should be applied with even greater force to a criminal defendant, because there's nobody in a criminal case who has a greater interest in the outcome than the defendant herself. So I think it's a very compelling argument. I thought another feature of the argument that was very persuasive was Mr. Grigsby's pointing out that the physical facilities of a courtroom are so extended these days by our modern technology that limiting the concepts to what's between the four walls of a courtroom is archaic. And to the extent that our courts have not come around to recognizing the vast proliferation of various types of media, not just televisions and cameras, but social media, they're still operating in a 19th century environment. And I think it's time for our court system to get into the 21st century, and perhaps Ms. MacDonald's case will help propel that. Yes, that's a very good point. The court was, at least one of the judges was indicating that how can we find that right in your behalf if no other court case has decided already? And again, I think that's a very short-sighted argument or analysis. Each case that establishes important rights comes out of an environment in which no case had been decided like that before. If it had already been decided, there wouldn't be a case. But much of our law, our important cases, Brown versus Board of Education, the famous D-school segregation case, cases involving reapportionment, cases involving women's rights, cases involving gay rights, the same-sex marriage case, all arose in the context of there's never been a case quite decided that way before. But the law is incremental. It takes baby steps up to the point where a sea change occurs. This case ought to recognize that the law is moving forward rather than just stuck in the past. If you take the position that there's never been a case decided like this, then you'll never have any change at all, and the law will be a force for conserving the worst elements of our judicial system rather than aspiring to the best. So I think another factor that kind of comes into play too is the appellate court frequently says, well, we're not here to correct errors, we're just here to find the law. But I think a court ought to say we're here more than to correct errors, we're here to avoid errors. And I think it would be a serious and grievous injustice and error of justice if Ms. MacDonald is not granted a new trial or a reversal of her trial because of the denial of her right under the Sixth Amendment to have media access to her case. Well, true, and I think generally judges have been very reluctant and resistant to have transparency in their proceedings. It goes a long way into how judges decide cases. Judges decide cases, at least in appellate bodies, they deliberate in secret. There's no transparency there. And judges who make determinations often do so without any accountability. And in fact, unfortunately, our judicial system is one of the least transparent bodies of government of all. And I think judges like it that way. They want to maintain as much secrecy and discretion as possible. And I think having media coverage makes their decisions better decisions. It makes them more accountable. And I think it improves the decision-making process because it necessitates more thoughtful deliberations rather than the kind of lesser thought processes that happen in secret. So I think there's a strain in the judiciary, not all of the judges, but I'm not condemning the judiciary. I'm just saying there's a long-standing strain in our judiciary to resist technological advances and transparency, in part to limit accountability.